which means why we sue. And in this class, we're looking at torts and contracts. It's going to be one of the two. I will not say this is a tort question, or this is a contracts question. But I will give you some facts that you can tell it's obviously not a contract or it's obviously a tort. Second part of litigation is you have to choose a jurisdiction. Or a venue. State, federal, 75K or above, 2 or more states, or above, state. Everything else. If you want to up your grade, state starts in circuit court. That is the beginning. Federal begins in district court. After you have a reason to sue somebody and you know where you're going to sue them, then you begin the lawsuit. Plaintiff does a complaint. Defendant does an answer. This is a person who sues. The defendant gets sued. The defendant then does a counterclaim, which is kind of like a new lawsuit back up against the plaintiff, and the plaintiff then has to answer the counterclaim, and that's called a reply. What are these called? Pleadings. Use that word, all right? Tell me about complaints, tell me about answers, tell me about counterclaims and reply, but then tell me these are the pleadings. These consist of the pleadings, okay? And the rest of your answer talk about the pleadings. It's important to know that word. Because if you don't have the pleadings, you can't have discovery. You can't have discovery based on just the complaint. You'd only have one side of it. Or just the complaint and the answer. You still wouldn't have all the information. So, tell me the cause of action, tell me the jurisdiction, tell me about the answer, counterclaim, complaint, and then call them pleadings. And after pleadings, the parties can go to discovery, which is exchange of information by deposition, which is in person. Interrogatory, which is written. Depositions and interrogatories are given to everybody's witnesses, all of the evidence, and it's exchanged for both sides. Unlike criminal cases where the police may know something that they don't have to tell you until you get to trial. Right? In a civil case, you get to know what the other side has. Why is it important to know what the other side has?
So you know how to counterclaim?
No, you've already done the counterclaim over here. After you get after the pleadings and you do the discovery, and now both lawyers know everything about the other person's case. Why is that important?
So you know everybody who you don't need to deal with.
Huh?
You know everybody who you don't need to deal with.
You know, everybody you don't need to deal with, that can be important in a little while when we're talking about the jury. What else? Huh? So you can build a case, that's true. What's always the answer if you're stuck? What did I tell you is always the answer if you're stuck? Time is money. Time is money. All of this right here takes 6 months maybe. To get to trial, to get to a jury, you're talking about another 18 months to 2 years. So if we're talking about a $10 million lawsuit, who can wait 2 years or 18 more months for their $10 million? I mean, nobody. I don't even think Jeff Bezos could do that. You know, if somebody owes him $10 million, he wants it now. So, because time is money, you do the discovery, and then what do you do with the discovery? Alternative to a trial, alternative dispute, which means we've got a lawsuit, resolution, which means we're going to resolve it. What's the first alternative dispute resolution? Negotiation. Now down here, near the time is money deal, we've got a judge. And that judge has a docket. And that docket is a list of all the cases. Leon versus Edmund, Leon versus Ida, Ida versus Benjamin. All right? And it's got 10 pages, maybe, of single line cases. And the Supreme Court calls the judge and says, Benjamin, are you settling? Are you close to it? Have you done discovery? And you say no, then he's going to say, you know, come to my office right this minute, bring the other attorney with you, and I want y'all to negotiate right now and see if you can't settle this case. Because he doesn't want to have to report to the Supreme Court, I haven't settled any cases this week. So negotiation, the judge pushes negotiation. What's the problem with negotiation? Not final. The two attorneys agree to split the difference, pay $5 million, and they go back to their clients, and the other client says, heck no, I want my day in court. I want to hold $10 million, or I'm not going to pay $5 million. So it's not final. So then we go to the second part of alternative dispute, which is mediation. And you have a person called a mediator who holds a mini trial. And they'll go to the conference room at the library, or they'll go to the conference room at the Holiday Inn, and they'll hold a mini trial. And the mediator will read all of this discovery. And the mediator will read all of these pleadings. And the witnesses will testify. And the evidence will be given to the mediator. And the mediator, without a jury, just one person, this may take a week. The mediator says, I think Corporation A owes Corporation B $5 million. Right? And Corporation A says, no, not final. Even though it may cost about $10,000 to do that, to rent the room, pay the mediator, pay the attorneys, if the result is something that somebody doesn't like, they can say, you know, it's not final. Now, why would they maybe say, okay, I'll do the 5 million? Why? Why would they do that? Time is money. All right? They may be out of business if they don't get that money. They have to pay employees. They have to buy supplies to put into their product, to sell to somebody else. So, you know, even though they may not like the result, they may say, okay, we'll do that. If they don't want the result, they can always go to arbitration. And arbitration is final. If you agree, I will go to arbitration. And arbitration is exactly like mediation. It's no jury. You've got one person sitting there, and they make a decision after looking at the witnesses and reading the discovery. And so if you go to arbitration, you say, yes, I will take that. Why is it final and everything else is not final?